3 months, even in a bankruptcy. Even in a bankruptcy. So, you have to tell your clients that if you really want this house, it might be worth waiting for. It might be worth sticking it out. At least give it 60 to 90 days. But there's no way to know. There's no way to guarantee. There's a lot of components when you're talking about a short sale. Throw bankruptcy in the mix and you have one more that's, could be a good or a bad.
Yeah, I'm actually in the opposite side of them. We took a listing. Our client gave us only a week, and then for the trustee sale. So on the 11th hour, at 2 o'clock in the morning before the trustee sale, he files for Chapter 7. It was with the B of A, 2 loans, and it was a rental property. So of course, when he files Chapter 7, it's all his assets, including the home that lives. What I'm trying to drive at, it's in the equator system with B of A. We didn't really do anything. BPO, actually we got a BPO right away that wants to see the property. Of course, we're having a problem having the tenants show that property. Like you mentioned, now it's with the bankruptcy law. So right now, the short sale, anything in the equator is null and void. What do we do at this point?
Repeat the last part of what you said. What's null and void?
Oh, no, because we did the short sales through the equator system, and the equator still shows like, hey, we're still, the short sale is still valid.
Right. Okay, you haven't executed the short sale at this point.
Yes, we did.
Oh, you did. You executed it.
Yes,
We already have a negotiator that's asking us to do the PPO.
Okay, but is the short sale executed? Like, is the sale complete?
No.
No, you're in the negotiating
No,
process. Okay,
negotiating.
so at this point, and your client has filed bankruptcy.
Right.
I mean, at this point, you're not doing anything with the bankruptcy court, because if it's a short sale, that means there's no equity in the property, correct? That means that it's not an asset. Chapter 7 trustee is looking for assets to liquidate for the benefit of the creditors. Your homes that you guys are dealing with are not assets because there is no equity in them, right? So you don't have to worry about anyone insofar as the bankruptcy wanting to prevent the short sale. In some cases where the bankruptcy case is still pending, you might need to file a motion with the court obtaining authorization to sell the home. I rarely do these, rarely, because bankruptcy Chapter 7 generally only takes 4 to 6 months, mostly only 4 months. And you guys will have executed your short sale probably in a little longer time than that. So what will happen is bankruptcy case will get closed and you guys will sell or complete the short sale after the bankruptcy case is closed. So usually we don't even have to do that. If we do, it's very simple. We do it, we get the authorization, and you proceed with your short sale. At this point, though, the bankruptcy should not be affecting your short sale process. Is someone at the bank telling you that it is?
No, the lawyer is telling
I'd be the
us.
bankruptcy lawyer.
The lawyer is the one telling us we're wasting our time.
Why? The lawyer for who? For your client?
Yes.
Because they said we shouldn't do anything
To jeopardize the
BK, and also he said.
Why would a short sale jeopardize the BK?
Well, I don't know, because they said because they don't want to have the PLOC that they have to pay proficiency.
But the Chapter 7 is getting rid of their...
I know. So we were in between the client.
This is a problem. I sit on the pro bono council.
Have their attorney talk to your attorney.
Listen, you know what? Yeah, you can. You can. I'm willing to give free advice. Here's the thing. I sit on the pro bono council, and I sit on that council with the U.S. Trustee's Office, with the now Chief Federal Bankruptcy Judge, because my bankruptcy judge retired. And one of the things that we talk about is all of these, and I'm not saying that their attorney is, we find a lot of people saying they're bankruptcy attorneys when they're not. So you have to understand, when the economy went south, I actually filed bankruptcy for a lot of attorneys because their practices went south. And what's hot? Bankruptcy law, right? So everyone jumped on what I call bankruptcy bandwagon, called themselves a bankruptcy attorney. Well, they think that just because bankruptcy entails a form that you can fill out online, anyone can do it. It's not true. It is very sophisticated. It is very complicated. Just by the mere fact that we have our own court and our own judges should tell anyone that this is not something that just anyone can do. And so you will have attorneys that really, unfortunately, don't know what they're talking about. That's ridiculous. That's absolutely ridiculous. If it's a short sale, there's no equity in the home. It's not an asset of the court. If they're in a bankruptcy, Chapter 7, they're being discharged of their personal liability on that HELOC anyways. It's actually a negotiating tool, like I mentioned earlier, for you guys to go to the second and say, hey, don't hold up the short sale. We'll give you a couple $1,000 and go away. Because if you don't take it, you're going to get nothing. If you don't allow us to facilitate the short sale, it's going to go to foreclosure and you're going to get nothing. So that's kind of crazy to me. I have no idea why they would say that, other than the fact that perhaps they don't really understand bankruptcy law. And unfortunately, we find that a lot these days.
Are you saying that you can still go through a short sale while your client's in bankruptcy?
Absolutely.
Yeah.
Absolutely. Do it all the time. All the time.
What are your fees?
I charge anywhere from $2,000 to $5,000, depending on how complicated the case is. We also take into consideration people who are on Social Security, disability, limited income will charge less accordingly.
But 13 is more complicated, usually requires a lot more.
13, you'll find pretty much across the board, all attorneys, because it's dictated by the bankruptcy court, will charge $4,500 for an individual and $5,000 or a W-2 employee and $5,000 for someone who's self-employed. But the way that we work is we base the initial payment on what they can afford. So maybe we'll take 50% up front and they can fund the rest of the payment through the Chapter 13 plan, which becomes an issue for us, not your clients, because if they don't complete the Chapter 13 plan, we don't ever really get paid that other 50%, but I never go after the clients for it. So.
And if I have a client that's just, let's say, relocated from another state, but living here now, and she files here, but the property's in another state.
That's fine as long as they've been here for, I want to say 180 days, but I think it's actually less than that. I think they changed the domicile requirements here. So yeah, that's fine. We file all the time for people who have out-of-state properties. I mean, so many of my clients are real estate investors, and you can imagine they have like 10, 20 properties abroad, so that's fine.
You said that the Chapter 7 provides leverage over the second, so that seems to imply that bankruptcy judges will tend to pay off the first as much as they can before they even give the second anything?
No. No one's paying anybody off.
Uh-huh.
When you're filing bankruptcy, especially for a property that has no equity that you're looking to short sale, no one's paying anybody off. What's happening is let's say I'm the debtor and I file for bankruptcy, okay? What that bankruptcy will do for me if I'm eligible for discharge is it will eliminate my personal liability on all of my debt that's eligible for discharge. First, second mortgages, even though they're secured, are eligible for discharge. They will be discharged. I will no longer be personally liable on them. Now, in a Chapter 7, you can't get rid of the lien. So that mortgage holder, even though I'm no longer personally liable, the note is gone, they still have their deed of trust. They still have the lien on the home, right? But what you're using as leverage insofar as the bankruptcy against the second lien holder is me, the debtor, I'm no longer personally liable on your note. You can't come back and sue me for it later. The bankruptcy is going to get rid of my liability to you. Now all you have is a lien. And what is your lien worth? Nothing, because there's no equity in the home to even cover the first mortgage. So now you should really take something that we're offering to secure this short sale, because if you don't, the home will go to foreclosure and you'll get nothing. So that's how you would use it. No one's paying anyone off. That's not the role of the bankruptcy court. It's actually the opposite. They're trying to allow you not to pay anybody off. Did I miss anyone on this side that might have had questions? Okay. Yes.
Like after the VK is complete, how many days, what is the timeline for us doing the short sale to complete it before it goes to auction, before it goes to sale later?
Again, that depends on the bank and how long they take to process that motion for relief from the automatic stay. So from the time that we file, I tell my clients you have a minimum of 45 days to negotiate something. And usually you guys know, once you've started negotiating, once you've gotten your negotiator from the bank and start negotiating that short sale, at that point, they're going to keep stalling foreclosure, right? Because of all the new laws implemented, and the banks are pretty scared and they don't want to do anything that would constitute unlawful foreclosure. So usually once you have your buyer and you've actually started negotiating a short sale, if you can do it within those first 45 days that they have filed the bankruptcy, hallelujah, because chances are you're going to be able to stall everything long enough that you're going to actually be able to execute, and I mean complete, the short sale. But the way that you asked it, I think you said once the bankruptcy is complete. Once the bankruptcy is complete, meaning the case is closed, meaning 4 to 6 months after they filed, the bankruptcy has no hindrance on a short sale. You can do whatever you need to do, but then keep in mind, once the bankruptcy case is closed, there's no automatic stay in effect anymore either, and the bank can proceed with foreclosure at any time. And I'm sure you guys are aware of foreclosure laws in California, but just in case you're not, let me give you the timeline of how it goes so far as your clients are concerned. Foreclosure proceedings start with the notice of default. So it's not the letter that they get from the bank that says, you are in default, foreclosure proceedings to, commence immediately. That's not it, right? It's the recorded document. It has a recording stamp with the county recorder's office, black and white. I should have brought an example of it. Notice of default, right? And election to sell under trustee's sale is normally what it'll say. Once they have recorded that, they have to wait a minimum, and I mean the banks when I say they, a minimum of 90 days before they can give you the notice of sale. Once they give you the notice of sale, they must wait a minimum of 21 days before they can actually have the sale. So you already know by that timeline how much time you have, right? And this becomes really, really important when you're conversing with your potential clients. Hey, you might not think my services are important right now, but just to let you know, this is your timeline. So if you've already gotten your notice of default, you need to contact me immediately, because every day the clock is ticking, and every day that you waste is time that you lose for options. Options are the most important thing that a potential client has. Whether it's your client or my client, they're all in the same boat. It's the most important thing, and they give up those options the minute they wait too long. By the way, something to note about that timeline, the best time to file a bankruptcy, if you're trying to get a short sale for your client or if your client's trying to get a loan on, is before they get the notice of default. It's the longest time extension they're going to get, because bankruptcy does not stop the clock running if they've already received the notice of default. So if they've already gotten the notice of default and those 90 days are running, bankruptcy does not stop the running of those 90 days. So remember that time is just being eaten up while they're in bankruptcy. That's one thing to remember. So the best time to file is before they even get the notice of default, because now they have not only the 90 days plus the 21, they now have all the time from the time that they file the bankruptcy till the time that the bank files the motion for relief. So they have a minimum of an additional 45 days added on to that approximate 4-month time period that they have. So that's something really important to keep in mind for your clients. Again, it's a selling tool for you guys to, and not because we're greedy and we want them to short sale their homes or we want them to, file bankruptcy. It's truly in their best interest. It really is in their best interest.
So then that would imply that if you're in the 90 days already, you would want to wait as close as you can to the sale?
Sometimes, yeah, and that would again depend on where you're at in the negotiating process, right? Like if you already have your buyer, and that's something we look at case by case. If you already have your buyer at that point and you have, you're still maybe 60 days from a foreclosure sale, I won't file BK for them because you already have your negotiator, you've already started the negotiating process. Probably within 60 days you're going to finish it. If we need to file bankruptcy for the client for other reasons, we'll do so after. But again, case by case basis, it depends on where they're at in the foreclosure process. It depends on where you guys are at in the short sale process. So, yes.
I have received some contradictory information regarding this fact. Do you think it is best if a person files for BK before they do the trustee sale, or after they before they do the short sale, or after they do the short sale? One attorney said before is the best time to do it, and another attorney said after is the best time to do it. What is your opinion regarding that? My
opinion is that there's no general best time. It's a case-by-case basis, just like we were just talking about. It depends on where you guys are at. If I have a client that's this close to a short sale being executed, they have already negotiated, the bank is about to accept, they have their buyer, all of that jazz, I'm not going to file bankruptcy for them, because now I'm going to throw them completely off the tracks, and they're going to have to go find a new negotiator in the bankruptcy department and risk the fact that that new negotiator might not accept the offer. And they might lose their buyer because of the fact that now the buyer's going to have to wait again. So, no, I mean, there's the only true advantage is if you don't have a buyer yet, and then you can, or if you're having a problem with the second, and you can use the BK as a leveraging tool. But again, it's never that black and white where you can say it's always better to do it this way, it's always better to do it that way. There's too many nuances involved that need to be considered.
How long does it have to pass in order for a client to refile another BK? Because I had a scenario where my client filed a Chapter 11 in 2009, and it was transferred to Chapter 7. And now we are in the process of executing the sale, but it's taking so long. So she's been asking me if she should refile for a BK.
Is her Chapter 7 done?
Yes.
She already received the discharge?
She received the discharge in 2010.
Okay, she received the discharge in 2010. So another misnomer. People think that you can only file every 8 years. It's not true. You can file as many times as you like, whenever you like. But here's what you need to know. You can only receive a discharge in bankruptcy every 8 years from Chapter 7 to Chapter 7. If you file a Chapter 7 and you then want to file a Chapter 13, in order to receive a discharge, you have to wait 4 to 6 years, depending on how long your cases are. That's not information you need to know. What you need to know for your clients is they can file to stop a sale anytime and as many times as they like. But here's what's important. The first filing of a bankruptcy, there is an automatic stay in effect until the lender files the motion for relief from the automatic stay. There were a couple of caveats to that, but it's probably a little bit too much information, and it's information that could be supplied at the time regarding timelines of, whether they don't file the motion, the automatic stay still gets lifted, blah, blah, blah. Too much information. So first filing, automatic stay goes into effect generally until the motion for relief is filed. Second filing within a 12-month period, automatic stay is only in effect for 30 days. Now, this is, again, one of those things you guys have to watch out for attorneys that don't know what they're doing. Second time you file within a 12-month period, automatic stay only in effect for 30 days. Your attorney must file and have the motion heard within 30 days in order to extend the automatic stay. This is really important because that means that because a hearing date needs to be noticed 21 to 28 days, that attorney needs to file that motion pretty much upon filing the second bankruptcy case, okay, in order for it to be heard on time. If there's a third case filed within that 12-month period, there is no automatic stay, not even for 30 days, until the attorney or the debtor files that motion to continue or install the automatic stay again. So really important for your particular client to know that just by virtue of filing, if it's within a 12-month period, which it's not for her, but if you did have clients, because we see it a lot, where there are multiple filings within a year, they can't just think that by virtue of filing the automatic stay is in effect or that it's going to remain in effect. You actually have to take more action beyond that.
But then if you get an automatic stay and they don't contest it, or is slow to contest it, and the clock is still, like you say, the clock is still ticking. I'm kind of confused. The automatic stay stops it, but doesn't stop the clock?
The clock that we were talking about was the foreclosure process, right?
Yes.
Is that what you're referring
Yes.
to? Okay. So the automatic stay, yes,
yes.
It is. See, this is why not everyone is a bankruptcy attorney. It's very convoluted. The clock on the foreclosure process, as far as the 90 days after a notice of default is filed or the 21 days after a notice of sale is filed, does not stop running no matter what. The automatic stay has nothing to do with that. Okay? The automatic stay will only stop their ability to collect on the debt, and one type of collection is foreclosure.
So basically what it is it can still go for foreclosure, but they just cannot collect on the foreclosure.
No, it can't go to foreclosure. Foreclosure is a type of collection activity. Automatic stay stays all
Okay.
collection activity, and foreclosure is a
Let me
type.
put my question different.
Sure.
Okay, so it goes to auction and sold at auction. The stay does not affect the sale of that property.
No, it does. They cannot go to sale as long as the automatic stay is in effect. As long as the automatic stay is in effect.
Okay, isn't the auction date part of the process?
No, okay, so here, no, now I understand what you're saying. Let's say, in your example, this would probably suit it. Let's say a notice of sale was recorded, okay? So now they have to wait 21 days to sale, right?
Mm-hmm.
Okay. The client files for bankruptcy, okay? Now, that 21 days still lapses, despite the filing of the bankruptcy. However, they cannot go to sale because the automatic stay is still in effect until they ask the court to lift that.
The action is stopped.
Yes,
So
the action is
The
stopped.
point being would be, let's say, for example, that the 21 days started, right? And then you file for bankruptcy. They cannot go to trustee sale. But let's say after the bankruptcy is lifted and completed, is discharged, they can foreclose the next day.
Exactly.
If they want to.
Exactly.
Because the 21 days already passed.
Exactly.
So
That's
it's not like they have to wait another 21 days. No, they can foreclose the next day.
Yeah, and there's another misnomer in light of that. The notice of sale under California law does not have to be reissued. So FYI to your clients, once that notice of sale is recorded, they never have to notify you of a sale date again. So absent the automatic stay of a bankruptcy, which is really the only thing that's going to protect them unless they have, a commitment in writing from the bank that they're not going to foreclose, they can go to sale anytime. Once that 21 days has lapsed, they can go to sale anytime.
So from that, you don't have to repost in the newspaper.
No, and that's a misnomer. Oftentimes they will. Like when I worked for the banks, at one time Pite Duncan shared their offices with I think it's Recon Trust or one of the major foreclosure companies. And, my experience was in the abundance of caution, they will. They will, because right now we have all of those cases pending about unlawful foreclosure, yada, yada. They don't really hold any legal weight, but, as attorneys and as a creditor attorney, we used to always tell our clients, Bank of America, whoever it was, in the abundance of caution, you should file the motion. Like, for instance, third bankruptcy filing. There is no automatic stay in effect. The attorney never filed the motion to continue or instate the automatic stay, right? There's no automatic stay in effect. If the bank wanted, they could go to foreclosure immediately. But what do we tell our clients as attorneys? Although legally there's no automatic stay in effect, in the abundance of caution, we highly encourage you to file the automatic stay motion, right? The motion to lift the automatic stay. I would say that that's the business end of the law firm trying to get as much business as they can. But when a lawyer tells you that and it's your lawyer, that's what you're going to do. So oftentimes the foreclosure trustees have the same incentive. They want to make money. They tell their clients, in the abundance of caution, you should really re-notify that notice of sale. But just don't bank on it. Your client should not bank on it.
Sure.
What happens if you have 3 people on title, husband, wife, and a child? The child's 22 years old. And then the husband filed bankruptcy, went through the bankruptcy, and we had the discharge. Okay, it's gone there. But the wife and the son did not file bankruptcy. Okay? Then what happens is still trying to do the short sale and everything, and they still don't work it out, and then the wife files bankruptcy.
I know this all too well.
Yeah. And then,
the multiple filers.
Then they have the bankruptcy, then they file the motion to have it relieved at the court. Okay? But they also file a motion saying that if another bankruptcy was filed, that they can't have an automatic.
It's called an in rem relief. In rem. And what that means is that the automatic stay is not going to pertain to this property. What they've done is they've attached the relief order to the property. So now it doesn't matter how many individual human filers there are. There is going to be no automatic stay pertaining to this property, in rem means property, any longer for 12 months to come. And I used to do a lot of those, and it's something that as an attorney, as a bankruptcy attorney now on the debtor side, I don't deal with. It would make me, it would ruin my reputation, let's just put it that way, because what that is considered is a delay tactic, and there are specific codes within the bankruptcy code, specific provisions that circumvent those attempts by multiple filers or familial filers. In fact, I say it in my retainer agreement. non-disclosure will cause me to basically drop you like a hot potato as a client. And one of the ways that I've seen clients do it is they will file a bankruptcy, and then after filing the bankruptcy, they will go on title on one of their friends' properties. So now technically the automatic stay is on that property as well to prevent a foreclosure. It's not looked upon well by the court to try to do it that way. There are better ways to facilitate the short sale or whatever the clients are going to do, rather than have all the people on title keep filing for bankruptcy, because they're not going to win that way anyways. And what's going to happen is eventually the judge is going to get teed off and prevent you from filing. They'll put what's called a 180-day bar, which means you can't file, or the lender will get in rem relief, which means that property is not going to be protected for a year.
If you have an IRS lien and you can't do how do they calculate the payments of an IRS lien for 13 if you're trying to set up
It's all incorporated into the Chapter 13 payment plan. So whenever you have an IRS lien, for instance, this is the horrible thing about an IRS lien. We can actually get rid of some taxes in bankruptcy. So any taxes that were due before 2008, 2008-7, anything before that are eligible for discharge if they meet certain other requirements, okay? The bad thing about a lien is you can't avoid an IRS lien in any form of Chapter 13 or 7. That's the horrible thing. They stick like glue. As far as the payments are concerned, in order to calculate them into your Chapter 13, and then eventually, once they pay them off, have the lien released, it's part of the equation. It just becomes part of the equation. So let's say they owe, $50,000 on their mortgage in arrears, right? And let's say they owe another, $10,000 in IRS debt that's now transcended into the lien. So you have $60,000 debt. Add on whatever other administrative expenses of the trustee and your attorney that go into that. But let's say it's $60,000, you divide that by 60, and you have your monthly plan payment.
So they're just going to take that amount. And
if the debtor can afford it.
That's what I'm saying. So that makes no depending on the amount, but that's pretty much a deal breaker right there. On a 13, because
if they can afford it, and you're right, because a lot of times it is a deal breaker, because most people that are in the situation that would cause them to be your client is because they don't have the funds to even pay their mortgage. So now how are they going to pay the ongoing mortgage payment plus the plan payments?
What about
Real quick,
student
Yeah.
Chevy Avalanche that's out here is going to be towed.
Anybody have a Chevy Avalanche?
Chevy Avalanche.
Going once, twice.
get ready to avalanche.
Into bankruptcy.
Now with the IRS tax regiment on the one that we talked about last week, does the IRS go with the person or does it stay on the property?
I'm sorry, just the what?
They do not.
Right, in a sale, if the property's foreclosed on and the seller because the seller had IRS liens, I have one that has an IRS lien that he's trying to get it released before the property goes to sale.
Okay.
So we can complete the short sale.
Sure.
But if it doesn't, and if my buyer tries to buy the property after, because to get the seller
does it stick with the property? Does it go with the person?
Yes.
It goes with the person. IRS has what's called a general lien. It's so horrible. So they can basically stick it anywhere. If the IRS agrees to release the lien, it'll revert back to the person, not the property.
If it goes to a foreclosure sale now because he couldn't get the IRS lien,
it'll go back to the person.
It doesn't stay with the property.
No. Because once you have foreclosure, the foreclosing bank, which is usually the first mortgage, is going to clear title. They're going to clear title. So whatever that takes. And usually the IRS will agree to release the lien once a foreclosure takes place because they know they can always go back after the original debtor.
What can we tell clients that are trying to go through that, suing with, the MERS or MARS?
MERS. I wrote a paper on MERS.
This attorney that I talked to, he's doing that whole thing, and now we can essentially badmouth, like you just said them, oh my God, what is he doing? Now this gentleman has to consult his seller and say, you might want to give Carissa a call. So now you have,
Here's the thing about, you're talking about the litigation to forestall foreclosure, and some of that involves MERS and who's the real note holder. I mean, that's the basis of that. Who's the actual party in interest, and the bank is not the party in interest because they're not the real note holder, and they have it with this artificial electronic company, MERS, and where is the actual note? In fact, Pite Duncan, unfortunately, went through a really horrible episode because of this very issue, where a former judge, Judge Bufford out in LA, had a 3-day trial with all of our clients and our firm, and talking about, do you actually have the note? Show us the note. You're not in a position where you can even file these motions for relief from the automatic stay because you're not the actual note holder. All it is a delay tactic. It's ultimately going to come down to, they're going to produce the note, they're going to show that they're a party in interest, the bank. When I say they, I mean the bank. And ultimately they're going to be able to foreclose. I will say this about that type of litigation, and I actually have a attorney in my office who does forensic audits and looks for different issues, not necessarily a MERS issue, but like a TILA issue or a RESPA issue within the note and deed of trust. It is a pretty good stall tactic, I will say. It is. And I actually deal with a real estate agent who works not only with me as the bankruptcy attorney, but also these types of attorneys that do these types of lawsuits. I personally never would, only because at the end of the day, I